Going along the lines of child safety, we do a lot of activities with our young people, especially high school students. And that can be anything from go-karting to swimming to whatever. One of the conversations that we've had in the past at our church is, do we want them to fill out a waiver? And I know you've mentioned this idea of a parental consent form. Can you talk about the difference between those two and the effectiveness of each of those documents?
Yeah, that's a good question. Very common question. A waiver or release of liability, it's an exculpatory document where you're trying to relieve yourself of liability for your own negligence. I have ethical problems with that. That's what we have insurance for, to cover damages associated with our negligence. But churches use them all the time. And one of the problems is they don't apply, children under 18 have no contractual capacity. They cannot enter into contractual agreements. And so a child that's 10 or 5 or 8 or 17, a child is anyone under the age of 18, they wouldn't have the ability to, or the legal status to sign such a form. And the key thing that a lot of church leaders don't understand is parents can't sign for them. A parent can release his or her own, can release the church from liability for damages to the parent, loss of society of their child if the child's killed, for example, pain and suffering, emotional pain that they may encounter because the child's a quadriplegic. But the parents cannot release any rights that the child has to proceed against the church for a personal injury claim. So they are very dubious value in youth activities. And so that's why I question whether you need them. But I do believe you need a parental consent form. And that form does four or five things. Number one, the parent consents to the child participating in this activity. You're going rope rappelling, you're going swimming at the lake. Well, my kid doesn't know how to swim in that murky water. They go under and you can't find them. You have about a 6-inch visibility. Those are highly dangerous events. And by the way, with regard to that, I never recommend any water event unless there are certified lifeguards on duty in that circumstance. And then the form should also identify whether or not the child can swim, if there's going to be any access to water. The form needs to give the parent the ability to say, I don't want my child participating in this event. You need to describe what the events are going to be. And if you do not want your child to participate, please identify. That's very important. And then, of course, you need to list medical conditions that may be relevant in the event of an injury, allergies, for example, if there's, depending on the food they're going to be eating. Those are all important components. And then, lastly, identifying somebody to make medical decisions, emergency medical decisions, in the event the parents can't be contacted. Of course, the form lists the parents' contact info, email, cell phone, etc. But in the event, it's rolled over to voicemail and you can't find anybody, you got to make this decision. The kid sitting there with blood spurting out of his neck, you have somebody that can make that decision. So that's important. Now, let me just tell you this. I read about 1,000 cases a month, and you say, well, that doesn't sound like much. Well, it's 33 a day, 7 days a week. That's a lot of cases.
A lot of cases.
And fortunately, I'm a speed reader. I have very little comprehension, but I can read quickly. and I came across, sometimes I read a case, Tom, that just stuns me. And that's what happened to me a couple weeks ago. I read a case, and this was a Connecticut court that dealt with a study abroad program by a private boarding school called Hotchkiss School. When I was at Harvard Law School, there was a lot of prep school graduates that were there, that had gone there, and a lot of Hotchkiss grads, Phillips Exeter, Phillips Academy, a lot of private academies in New England that a lot of people aren't even aware they exist, but they are boarding schools. You send your 8th grade child, 10th grade child to these schools. They stay there just like college dorms, and they're like fast tracks to get into Ivy League colleges and then graduate schools. And that's what Hotchkiss is. They've had some very eminent alumni from that school. And they took a group of 15, 16-year-old kids on a study abroad program in China, and to just immerse themselves in Chinese language and culture for 1 month. And they were doing some hiking on this trail in northern China. And at the top, the group leader decided, okay, let's go back down. And 3 of the girls said, we're going to take a shortcut. We're going to cut through the brush over here. So they went through another, they went down the hill a different way that took them through vegetation. And when they all got down at the clearing down below where their bus was, one of the girls that had cut through the shortcut, I mean, she had chigger bites all over her. And one of them did not heal. In fact, it grew. And after about, on about the 12th day or so, she started experiencing paraplegia, intense fevers, dementia, and what they ended up doing was calling her parents, of course, and the dad flew out to China and picked his daughter up and took her back to New York City, put her in a hospital. She was diagnosed with TBE, tick-borne encephalitis, and long story short, she did experience permanent brain damage. And so the parents, on behalf of their 15-year-old daughter, sued Hotchkiss School and won a jury verdict of $40 million. I was stunned when I read this. What did they do wrong? The plaintiff's attorney said, you didn't contact the Centers for Disease Control and find out if that area of China was on a watch list or on some warning area, and you didn't follow the basic recommendations that are right on that website. So, I mean, the application of that case, as I read it, to churches was just phenomenal, because think of the thousands of churches in this country that send kids overseas on short-term mission trips to third world areas without the slightest idea what we're exposing them to. So this case stands for the proposition, if you're sending a group of kids, and I would say anywhere in the US or overseas, because there's an outbreak in a number of states now of West Nile virus, which is potentially fatal. It's shown up in Oklahoma, Kentucky, Massachusetts, I mean, it's a widespread geographic distribution. And so check out the CDC website. The area where we're taking these kids, and it can be adults for that matter, are there CDC warnings about this area, and what are the prophylactic, the preventive measures that are recommended? And if you follow those, you see what I'm saying? That's the federal government telling us what to do, where not to go, or if we do go to certain areas, here's what you need to do. All of that is there on that website. And that's what the plaintiff's attorney said. Had that school done this, this case would never happen. They talk about the kinds of insect repellent to wear, the kinds of clothing to wear, and how to inspect yourself for ticks periodically. And it's a very effective, very thorough website. I've reviewed it. And of course, I think as well, to expand upon that would be to contact a local physician for additional recommendations that deals with infectious or insect-borne or tropical diseases. What other, you can say, here's what we're doing based on the CDC recommendations. Do you have any further recommendations? I mean, just think, what's the jury going to say if you do that much? You follow the CDC recommendations. You contact a local physician for additional recommendations. How is that negligent? You were reckless in sending those kids over. I think you've got an excellent case. I think that's an issue for every church that's sending groups, and like I say, it's not just minors, but it's also adults, to make sure that you are apprising yourself well in advance and informing parents of what these risks are. And do you still want your child to come? Here's the risks, here's what we're going to be doing about it. The parents need to be involved, which they were not completely in the Hotchkiss case. So I think there's a lesson there for church leaders.
One of the things too that was interesting about that case is there was a waiver of liability and a release signed.
Let me mention that, Jerry.
Okay.
That's a good point. The parents did sign a release of liability, and the court threw it out. Why? Courts hate waivers and releases of liability because you're trying to relieve yourself of consequences for what you've done. And so the court said they hate, and so they look for any way to avoid these things. And so they came up with several reasons why they avoided it. Number one, it didn't explicitly identify the risks involved. Harm of any kind, injuries of any kind, forget it. You've got to itemize those risks. They have got to look down that list and see exactly what happened to that kid, which they didn't have tick-borne encephalitis on their list. So they threw it out for that reason. And then they talked about it's a contract of adhesion, which is a legal concept, which means take it or leave it, just like going and renting a U-Haul with that 15-page form. You say, well, I want to change item number 78. I mean, they're going to say drop dead. You know, that 18-year-old clerk that doesn't know that has no authority. So if you're in a take it or leave it situation with no opportunity to negotiate or the terms, that's an adhesion contract, and the courts looked with extreme disfavor on those. It violated public policy, trying to relieve an entity from liability for injuries, catastrophic injuries to a minor. And so for these and among other reasons, the court threw that out.
So as a church, we would be better served to forget about waivers and use a good parental consent form that details the activities that are happening and have one for every activity.
Yes, yes. And you can do a waiver for adults,
okay.
But I prefer, because an adult can waive, but it gets to be that ethical component again. Is that what we want to do? We have insurance to cover these people for injuries that are due to our negligence, and do we really want that? Something else you might consider is what I've recommended for several years is an assumption of risk form, where an adult can do this. You're going to a third world country, and you can, there's all kinds of risks of tick-borne or insect-borne diseases, of inadequate medical care, inadequate transportation, terrorism, who knows what it is. Adults have the right to assume risks as long as they're known risks and it's a voluntary assumption. Those are the two requirements. So again, you need to explicitly list what the risks are, and then a voluntary, I understand these risks and I voluntarily assume them. Adults have that right. There's been a few cases, including Connecticut, where courts have refused to recognize assumption of risk forms for adults too. But the vast majority of states, they are binding contractual commitments. So I do recommend, if you're sending a group of adults on a short-term missions trip, like our church is sending a group to Cuba, and Carter is a JFK fan, so I pronounce Cuba the way that JFK did. Cuba. Having lived in Massachusetts, you know, there's a very simple rule. Any word that ends in a vowel, you put an R on the end. And any word that ends with an R, you take the R off. If you remember that, you're going to do fine in Massachusetts. But we're going to, we haven't talked about this, but I'm assuming we'll be doing assumption of risk forms.
We have them together.
We have them, okay.
A follow-up question to that question of the consent forms. I know some places that have, you know, in the context of your kind of annual youth ministry events or annual kids ministry events, try and make an annualized form that, you know, asks the question, can the child swim, and here's kind of the parameters of the events, and they get it notarized. It gives a release to treat medically if a parent's unavailable. Are those something that's a good thing to use, or is it better to do one of those individually for each event?
Well, there's no litigation, no precedent addressing that, Carter, so we can't say for sure. I just anecdotally know that there have been a few cases, just you can count on one hand, where these forms have not been recognized by emergency room physicians because they were too generic. So, and mainly it was because they didn't identify who the person was who could make the medical decisions on behalf of the family. In those cases, they listed like the youth pastor, and in fact that person had changed office in the past year. So I think a year-long form is going to be fine as long as you, again, explicitly list what those risks are and what the activities are going to be. You know, not every event's going to involve swimming, but you can say, here are the activities that we're going to be engaged in for the next year: swimming, hiking, list them all. And I think under those circumstances, and most importantly, if you identify, let's say 3 people, any one of these 3 people can make emergency medical decisions, and you're reasonably certain that at least 2 of them are going to be around for the next 12 months, maybe only if it's just 1, but you've got 3 individuals named. And I think that overcomes the resistance I've seen in a few cases by medical room staffs to these forms.
Do you think it's still good to, especially for, I'll call them riskier events, do a parental permission slip or something like that, that details the activities going on at this specific event?
I'm not opposed to that, but I think it can be incorporated within the more generic form if that risk is identified. like we're going to go rope rappelling down a 100-foot cliff. You know what, a parent is right in mind. This is an extremely high-risk event. Do you want your 6-year-old doing this? We had a kid at our church
No, I don't want my
that
sister.
was rope rappelling and a youth activity and fell 100 feet under rocks. And he got up and he walked back to the group.
Oh, my
and
goodness.
his mother said, I think it was a miracle.
I think it was.
No, I'm not saying the green light is on now. We can start.
One more follow-up there, Rich. How long, if we have whichever form we're using, how long do we need to hang on to those?
Well, you mean for assumption of risk forms or parental consent?
Parental consent, for particularly with regard to minor.
Yeah. Well, obviously, you want to keep them until the child is an adult, 18th birthday, plus whatever the statute of limitations is, at an absolute minimum. If it's an adult, I think you're good with whatever the statute of limitations is on personal injuries in your state.
Will an electronic copy of that archive
Yes.
suffice, or
It
does
will.
it need to hold on to the paper?
Yeah, it will. And if you have, you know, electronic storage is becoming so efficient and simple. I mean, so in the old days when everybody had to keep paper copies, the originals, it got to be a real problem. What's the soonest point we can destroy these things? But if electronic storage is not a big issue, then I would say keep them longer than shorter. And you know, because statute of limitations can be extended in some situations way beyond what the law says. You know, it says, like in Missouri, we have a 5-year personal injury statute of limitations, and so you'd want to keep an assumption of risk for at least 5. Why not keep it 10, just to be sure that we've got it? You want to have that form, obviously. That's critical. An assumption, and I think that's an important point, is the strategic importance of the form. So some forms, like invoices, you know, so what? Get rid of them. But when it's an assumption of risk, that is the, you know, what should I say, the most important document you have to defend yourself in the event of litigation. So why not keep that for an extended period of time? I think there's got to be a qualitative analysis of the document in determining how long we keep it.
I would suggest for camps, if you're going to have a camp, because there's so many specific things that the campers do, that each camp you'd have their own forms. But you know, that's the only, you know, that's what I see is when they go camping. I mean, they could be doing whitewater rafting, rappelling,
Zip
zip
lines.
lines. You know, they're doing all of
Firearms.
that sort of thing.
And you know, the 10-year-old's jumping up and down. I can't wait. And mom's looking at this, she's like,
No
whoa.
way.
Yeah.
Mom can wait.